Josh Klipp. I am the founder and principal of Made Welcome, which is a consulting firm focused on accessibility at workplaces and events. I am a recovering attorney. I like to say I spent over 16 years in the public sector working for various government agencies specializing in the ADA. I left litigation to start my own consulting practice, which is Made Welcome, and I also am a certified access specialist through California's Division of the State Architect. My current clients range from state and local governments covered by ADA Title II, as well as large retailers such as Starbucks, covered by the ADA's Title III. And I also teach a certification course on event accessibility. Failing to provide meaningful access for customers with limited English proficiency or who have communication related disabilities can always lead to complaints or lawsuits or bad publicity. But for small to medium sized businesses, these can be exponentially more consequential because generally their financial margins are much more limited. So while one lawsuit or social media post isn't going to sink a big company, it could do a lot more damage to a small or medium sized business. In terms of accessibility, the simplest, cheapest first step is to simply go online and do a little self-study on what are considered effective communications. I personally spend a lot of time on ada.gov and the US Access Board's website whenever I have a question or want to learn some sort of simple foundational information. From there, I'd say have a company policy, do a short training, and set expectations for you and your employees about how an effective communication scenario would be handled. And I'd recommend similar steps in terms of language access. The US Department of Health and Human Services currently has a page that has a lot of basic information and resources to help you get you started on something like that. The bottom line is that if your business receives federal funding, then you're expected to comply with Title VI and ensure equal access for customers with limited English proficiency. But I'd add that if you're not sure if you receive federal funding, you can first look at the Department of Justice's Civil Rights Division webpage that goes into this in some depth. And if you're still not sure, then you may at that point want to consult with an attorney. We're going to break this down into some component parts. We'll start with Title II. So the ADA Title II deals with state and local governments and mandates that these entities ensure that their programs, services, and activities are accessible to people with disabilities. So if your business is involved in assisting a Title II entity in the delivery of programs, services, and activities, you need to make sure you're doing that in a way that's accessible. So for example, if you built an app that a state or local government wants to license, so for example, an app to pay your parking meter. Parking meters are a service of a local government. So you need to make sure that your software to interact with parking meters complies with WCAG 2.1 AA. In terms of providing interpreters, let's say ASL, you need to be sure that you have some qualified ASL interpreters who are capable of providing effective communication. Some states have guidelines or regulations or even certifications for interpreters. So as a business providing ASL interpreters, you need to be sure that they meet those baseline requisites to ensure that the Title II entity is providing its constituents the mandatory effective communication. As for Title II and documents, if these are digital documents such as PDFs, then you should familiarize yourself with the accessibility checking features of Adobe, for instance, and make sure that those are providing or creating PDFs for a Title II entity that meet those accessibility standards. Okay, let's talk about the ADA Title III. Now, the ADA Title III addresses accessibility in places of public accommodation. In most instances, this means your storefront or your public counter or lobby, but now even perhaps your company website will be subject to the requirements that places of public accommodation are accessible to people with disabilities. So what you're required to make accessible really depends on what products or services you offer. For interpretation services, again, we're talking about effective communication. If you're a small coffee shop, this could be something as simple as a pad of paper next to the cash register, or having an iPad nearby with translation software installed. As for translating documents, I'm hard pressed to come up with an example of a small to medium business being required to provide translated documents, short of Title VI applying because you receive federal funding. But just looking around, where we see translated documents being most ubiquitous is when your business is global and translations are useful to your customers. For example, if you order something online from an overseas company and that item requires assembly, most products arrive with a booklet of instructions in about six different languages. As for accessible digital content, again, WCAG 2.2 isn't currently mandated for places of public accommodation under Title III, but lawsuits about digital access for public accommodations are skewing toward requiring compliance with basic WCAG AA standards. Section 508 applies to federal agencies, and WCAG 2.1 AA now applies to ADA Title II entities, which are state and local governments. So if you're a small or medium-sized business who does business with any of these, federal agencies or state or local governments, then the digital products or assets that you provide to these entities need to comply, period. There aren't standards that are more critical, they're all just required. If you're looking at which standards are most critical in terms of the products and services you provide to the public generally, then I think you need to focus on what is the primary business you're engaged in. And that's how courts have typically looked at it. One of the first digital access cases involved a place of public accommodation selling goods online. The lawsuit, however, had something to do with an ancillary function of the website. In that case, the court ruled that the public accommodation, the sale of the goods, was accessible. And the fact that some ancillary function wasn't accessible didn't put that business in violation of the ADA. As I mentioned, though, earlier, this is all evolving. In terms of what's critical, you should first make sure that the products or services you offer to the public are accessible. In terms of translation services, I'll refer you back to the ways in which WCAG intersects with language translation. Specifically, you want to make sure that your digital assets interact with screen reading technology such that it's clear to the screen reader which language your website features. Also, you want to apply the WCAG principle of understandable, using plain language, and this is going to assist in the accurate translation of your website into other languages. Legal consequences are potential complaints and lawsuits, which in and of themselves can be expensive, especially if you don't have insurance for that. And the financial consequences, other than the legal fees themselves, can really vary depending on the severity and repetition of any violations. If you mean what's my advice around ensuring that your company can do business across multiple global sectors and languages, I'd say find the best translation software out there and make sure that your products and services are available in the languages across the markets that you want to reach.